Today we are going to discuss about the functions and powers of the High Court. So you all know about the Supreme Court is the highest power, and followed by that next it is High Court, and next will be your subordinate courts. So this is the single integrated judiciary system. So the topmost will be your Supreme Court judgment. So what are the high courts? Let us see in the state. Okay, so in Allahabad there is a high court, in Mumbai, in Delhi, in Karnataka, Guwahati, and Punjab and Haryana, Rajasthan, Patna, Kerala and Sikkim. We have high courts on these places, these states. Okay, so let us see the composition of high courts. So each state has one high court. The high court is headed by Chief Justice of High Court, and he is assisted by other high court judges. If required, Parliament can also increase the number of additional high court judges to clear the pending cases. So each and every state has one high court, and Chief Justice is the head of the high court, and he can be assisted by various other judges also, and it is nominated by the Parliament. So let us see the qualification for appointment of judge of the High Court. He or she should be a citizen of India, and it should not be more than 62 years, and held a judicial office for at least 10 years, or he should be worked as an advocate in High Court, that is 1 or 2 or more years, that should be at least minimum 10 years. So the main is that his age should not be above 62 years, and he should be a citizen of India, and he should have a service of 10 years as an advocate. So every judge of the High Court is appointed by the President in consultation with the Chief Justice of SC and Governor of concerned by the state. Chief Justice of Supreme Court and Governor. By their knowledge, every judge has been appointed. So in case of appointment of other High Court judges, it is done by the Presidents in consultation of Chief Justice of Supreme Court and Chief Justice of High Court, and also Governor of the state. So the term of office of High Court judges, the judge of the High Court can hold office until he reaches up to 62 years. So maximum 62 years of service he can be as a judge in the High Court. Okay. In case of resignation, High Court judge need to submit a letter to the President. Let us see the condition of services. That means removal, retirement, transfer, salary, and restriction on practices. Okay. So removal of High Court judges. Judges cannot be removed by normal simple procedures. So a judge of the High Court can be removed only by the President on the grounds proved misbehavior or incapacity. So the removal of High Court judges is done only by the Presidents. That is by the ground of misbehavior or incapability, and approval of 2/3 of majority of both the houses is also needed to go ahead with the impeachment of High Court judges, and the retirement of age of the High Court judges around 62 years. Next is salary and emolument of High Court judges. So the salary and allowance cannot be changed by the Parliament or anyone except during the period of financial emergency. So the salaries for the High Court judges is fixed. Okay, so they are provided a rent-free accommodation with other allowance, and it is paid from consultation fund of the state. So next, let us see the transfer of High Court judges. So Presidents can also transfer the High Court judge from one High Court to another High Court based on the certain condition. It is done in consultation with the Chief Justice of the Supreme Court, and it is also done in consultation of 4 senior-most Supreme Court judges, and it is approved by the High Court judge of the Chief Justice and another Chief Justice of the High Court. So the Chief Justice who is transferred to another High Court is entitled to get a compulsory allowance in addition with respect to his salary. Okay, based on the norms and condition, he can also get additional allowance with respect to the salary. Next, let us see about the prohibition and restriction of the practice after retirement, which means the High Court judges are paid handsome pensions, but they are not allowed to practice after retirement. Okay, so it is mandatory that they should stop the practice after their retirement, and this is done so the High Court judges do not get a partial towards any future employer. Okay, this is also stop them from using their influence with their other former colleagues if they are allowed to practice. Okay, so we saw about the prohibition practice after the retirement, and also about the transfer and salary and service condition, that is retirement and removal. Let us see the powers and jurisdiction of High Court. So the jurisdiction is the power that the High Court of the law exercises to carry out judgments and enforce law based on original jurisdiction, appellate, advisory, reversory, and judicial review. Jurisdiction. Jurisdiction is something that the authority of the court to rule a certain case. Example, the Supreme Court has a power to over other to the entire United States. Okay. So original jurisdiction is something the power to handle the cases which cannot be moved in any other court other than High Court. Okay. These cases include state revenue and its collection and protection of fundamental rights, and cases related to divorce and interpretation of constitution and election petition. These are can be only performed in the High Court. Next, appellate jurisdiction means the power to handle the cases on appeal against the judgment delivered by any other district courts or subordinate courts. So, if the result which is in the subordinated courts or district courts is not valid, he can appeal the cases to the High Court. So, these cases are included into two types. One is your civil case and second one is your criminal case. So, the important case within the district court, certified or without DC certifieds on appeal. Example, land revenue. Those things can be appealed to the High Court, and criminal cases also with DC verification or without DC certificate, it can also appeal. So, next is enforcement of fundamental rights. In case of fundamental rights of any individuals are violated, such individual can directly approach the High Court. So, High Courts like Supreme Court has a power to issue the rights of habeas corpus, mandamus, and writ of prohibition and writ of quo warranto for enforcement of fundamental rights. Writ is something that an order of a judicial authority asking a person to perform or not to perform an act. Next is your advisory jurisdiction. So here any government department, legislative or governor may refer or send a cases of special importance or regarding any law for consideration to the High Court. This power of High Court to handle such cases are called advisory jurisdiction. Next, last one is a revisory jurisdiction. So High Court is empowered to review any judgment or order made by any subordinate courts with the review of removing any mistakes or error that might be crept in the judgment or order. This power of High Court is called revisory jurisdiction, and this is done in the case of belated injustice, error of law, wrong judgment, flagrant error of the procedures. So the last one is your judicial review. So High Court has a power to review laws passed by the state legislative or any other local authority. If the law is found against the spirit or provision of constitution, then the High Court can declare such law that is ultra vires or null and void. This power is called judicial review. So let us see what is court of order. High Court is a court of record as its all judgments are recorded for evidence and testimony, and these judgments serves as a precedence for subordinate courts, so that in case of doubts they can refer the records of High Court and give similar decision as High Court. Okay, so the High Court records all High Court's records are not questioned when they are proceeded before any subordinate courts. They have to just follow whatever the decision taken by the High Court. So if the High Court can punish such person, its contempt and one deny on its rights of High Court. So the High Court is divided by subordinate courts and local tribunals. So subordinate courts are the courts that function in the district level. So it handles the cases of civil court, that is district judge, criminal court is session judge, and the court of revenue. So the court of district judges and session court. It is high level civil court of the district, and it is a high level criminal court, that is said to be your session court. It is president, whereas the court of district court is president by district judge. Here it is president by sessional judge. It also the district judge handles all the civil cases like land, property, marriage and divorce and will, whereas the criminal case, murder, theft, pickpocketing, these are handled in session courts. Okay. So local adulterants. So local adulterants mean people's court. Justice by P.N. Bhagwati and Lok Adaltons were set up in 1897. It was said to provide legal help and quick judgments to those who can afford expensive fees of lawyers and also expenses of legal proceedings. So, decision of Lok held Adelaide is considered as a decision of a civil court. So, this is something that places like factories, farms, and commercial complexes and neighboring neighborhood, these all will come under local adult's meaning. Okay, so how it works? It works, judges, law coordinators, public workers or social workers inform the litigants about the rights and duties. The judges of local adultants are actually counselors. These adultants are assigned by a legal aid committees and social action group. So the first look of local adultants was held in Jurang in Gujarat at March 14, 1987, 82 I think. So what are the main advantages of local adultants? It works in the spirit of harmony, compromise and understanding. Both parties feel satisfied, and also it delivers a fast and inexpensive judgment, and it reduces the workload of other courts also, and it reduces the delay in high courts, and providing a legal aid to a weaker section of the society. So we saw about what are the advantages of local adults: fast and inexpensive judgment, and providing a legal aid to a weaker section of the society, and reduce the workload and delay of other, and both the parties are feel satisfied. So if you have any clarification related to this topic, please feel free to contact me. Thank you.